inquiry has accused Israel of deliberately targeting and killing Palestinian children in Gaza, resulting in genocide, crimes against humanity and war crimes. The Independent International Commission of Inquiry on the Occupied Palestinian Territory examined violations against children during the war in Gaza. It says Israeli forces deliberately shot children with drones and sniper rifles, targeting vital organs, and said it had proof of war crimes. The Israeli government has rejected the findings, labelling the inquiry flawed and biased.
Chris, it's very nice to meet you, virtually, of course.
Yeah, virtually, but yes, Brian, very nice to meet you as well.
Yeah, thank you.
Now, let me introduce and welcome my two guests today on the Israel Connection. Firstly, Chris Sidoti, who was involved a few months ago in a debate with 𝔸𝕟𝕪𝕨𝕙𝕖𝕣𝕒 from the Israel Law Centre, 𝔸𝕟𝕪𝕨𝕙𝕒𝕣 on my show. In November 2025, Chris Sidoti was appointed to a second term on the Independent International Commission of Inquiry on the Occupied Palestinian Territory, including East Jerusalem and Israel. Chris is an Australian expert on international human rights law, a lawyer and advocate, a former Human Rights Commissioner in Australia, and a former Commissioner of the Australian Law Reform Commission. Welcome back to the program, Chris.
Thanks very much, David.
And Dr. Brian Cox is a Senior Fellow at Macdonald-Laurier Institute in Canada. He taught international law at Cornell Law School from 2019 to 2026. In 2018, he retired from the US Army after 22 years of military service, including 7 years as a military lawyer. As a legal advisor, he served as a military prosecutor, federal prosecutor, and brigade just advocate, among other assignments. His combat deployments include Iraq from 2003 to 2004 as a combat camera operator, and Afghanistan from 2013 to 2014 as an operational law advisor, and then as Chief of International and Operational Law for Regional Combat East. And to start off this discussion on the contentious International Commission of Inquiry report that maintains that Israel has been deliberately targeting Palestinian children in the occupied Palestinian Territory since October the 7th, 2023, I invite you, Chris, to provide us with an outline of the case made in the report that you have produced together with the other members of your committee.
Thanks very much, David, and thank you again for having me on your program. The report deals with more than just the question of whether there is targeted killing going on or not. It deals broadly with the situation of children in the occupied West Bank and in Gaza, and in particular during the period from 7 October 2023 to around about the same date in October 2025. So it focuses on a 2-year period. Amongst the findings that we make in the report is an examination of the deaths of limited number of children and the broader experience of doctors, foreign doctors who have served in Gaza as part of emergency teams. And we came to the conclusion that in the case of the deaths that we examined, and then more broadly through the evidence that we received, there had been deliberate targeting of children. This was one of the findings that we made in that report. Of course, the number of children that were deliberately targeted and killed that we were able to investigate was limited and is far less than the numbers of children killed as a result of the Israeli strategy of total bombardment of Gaza. So the death toll in Gaza has been very high indeed. The death toll in the West Bank is much less, but still increasing, particularly over the last almost 3 years, and a matter of grave concern as well. So the report deals more generally with children, not just on the question of targeted killing. It's the longest report that we have produced, and it involved the consideration, the detailed investigation of a limited but significant number of cases.
Right, we'll go into more detail, I suppose, on some of the examples as we progress. But let's hear from you now, Brian, with your initial response.
Yeah, so as I read this conference room paper that was recently published in June 2026, as well as many of the other reports that have been presented by the UN Commission of Inquiry, I'm really struck by really 3 factors that stand out for me as someone who has a lot of practical experience and operational experience dealing with international law involving armed conflict. And the three main factors that I focus on, not only for these materials, but also for other materials and reports that are published by human rights organizations and NGOs as well, the three main factors are the evidence that's presented, how the report presents the law, international law, especially involving armed conflict, that it's going to use as an analytical tool, and then the methodology that each report puts together by taking the facts, applying it to the law, and then developing findings and conclusions. And in each one of those categories, in evidence and in the way that the law is articulated, and then the methodology of each, I find that there are significant limitations and deficiencies that really need to be addressed if we're going to consider the findings and recommendations of this report as a whole. And then as well, again, since we're focusing specifically on the UN Commission of Inquiry, on its work in general as well.
Okay. Now, there have been some analysis of the report that you've produced, Chris. I have to say that we're conducting this discussion now because I feel that there's been rather superficial consideration of the detail of the report, and I think because of the length of the report, it is really a daunting exercise for anybody to dive in and analyse the extent of detail, and that is why we're having this discussion today, to do a little bit of a deep dive. Can I ask you, Chris, have you read in detail the response to your report written by 𝔻𝕖𝕓𝕒𝕒𝕒 on behalf of the organisation UN Watch?
I have seen it. Depends what you mean read in detail. I have read it, but I haven't laboured over every word.
Well, just for the benefit of my audience, 𝔻𝕖𝕓𝕒𝕒𝕒 is an independent scholar and author who writes about anti-Semitism and the Israel-Palestine conflict, and currently serves on the board of Honest Reporting. In its introduction, it states, despite the extraordinary nature of these allegations, the report fails to provide even a single verified example demonstrating that Israel Defense Forces, the IDF personnel, identified an individual as a civilian child and deliberately selected that child for death for no purpose other than killing the child. Instead, the report repeatedly substitutes the tragic fact that children died during the war for proof of deliberate targeting. There's a series of items that are mentioned in this detailed analysis by him, and it's worthwhile to go through some of these, I think, as we speak.
Well, if I may interrupt, David, I'd rather hear from Brian. Brian's here, and you know the extract that you've just read is the reason why I have not laboured through that report word by word. They're just plain ridiculous ideological statements. So let's hear from Brian, shall we?
Yeah, okay. Well, yeah, I just wanted to point out that there is argument that is out there, and I think Brian will expound hopefully on what a lot of that is. Yeah, go ahead, Brian.
Well, I've also had a look at this the report by 𝔻𝕖𝕓𝕒𝕒𝕒𝕒, and he raises a lot of the same issues that I consider as I'm reading the report as well. And one of the main ones is, and that you mentioned just kind of in your overview of that report, is that there are evidentiary limitations that are inherent in not being able to go into the battle space to be able to directly speak to the people who are potentially on the receiving end of victims of armed conflict, but even especially more importantly, and this is where the evidentiary limitations are inherent within the UN COI reports, is we don't have input at all from the Israel Defense Forces, from specific soldiers who are or troops who are engaged in attacks. And so if we just take evidence after an attack and say, oh, so we've talked to doctors and in Gaza, and the doctors have said that these attacks were carried out by the IDF, we're getting secondhand knowledge from medical facilities rather than from developing intent and knowledge from the personnel who are responsible for the attacks at the time. And that's what we really need in terms of analyzing the conduct of hostilities and whether war crimes have been committed. Is we need evidence of the actual individuals who were responsible for the attacks rather than secondhand evidence that was provided through intermediaries afterwards.
I agree with your comment, Brian, on the limitations of the evidence, but I don't agree on the inability to draw conclusions from the evidence that we have. We're not able to visit the site, you're right, and we're not able to speak to the individual soldiers. The Israeli authorities have consistently denied us access to Israel and Palestine and the ability to speak to soldiers. They have denied access to doctors, for example, who were involved in the examination of bodies after the massacre of 7 October 2023. We asked them at the beginning of each of our investigations to provide commentary and evidence, and they don't. And we provide them, and to me this is the most important aspect, we provide them with a copy of our reports in draft form and request that they respond, and they don't. So there is that limitation, a significant limitation. But I disagree with you. Where I disagree with you is that it's not possible to draw conclusions from the evidence that we have collected. Courts do this all the time. We're not a court. I'm not suggesting that we are. But it's a process well known to both US law and the common law applicable in Australia and in Canada, that you can draw conclusions from all of the evidence that is available. And if the evidence is sufficiently compelling, then you make a conclusion at the standard of proof that is required for the particular proceeding. The standard of proof for a commission of inquiry is reasonable grounds to conclude. We're not a court. It's not a criminal court in particular. So we don't have to make a finding beyond reasonable doubt. But a court would make a finding in a criminal case on the basis of the kinds of evidence that we have collected. I don't accept that the evidence of medical doctors is secondhand evidence, in that what they report to us is what they actually see. That is the results of their own forensic examination of the bodies. They can't tell us how a child was killed, but they can say that there was no shrapnel on the body, that there was only wound to the head or to the upper torso, that there were no signs of any other form of injury, so that they know the cause of death, and they know that it was the result of a bullet that hit very precisely in a part of the body that causes death, so that the head, the heart, the lungs. That's direct evidence from doctors of the nature of the death. But it's certainly, I agree with you, it's not evidence of intent. And here, like a court, this is where we draw the conclusions based upon the circumstances and the inferences that can be drawn. But one thing I would emphasize is that we never form a conclusion based on one piece of evidence alone. We have to have at least 3 pieces of evidence independent of each other, and mostly we have many more pieces of evidence than the 3 minimum that we impose upon ourselves. And that could include eyewitness evidence, video evidence, satellite imagery, the kinds of forensic examination that I have referred to. We have 2 independent forensic pathologists. We have a military expert. We have a digital forensic expert. We have experts in child rights and sex and gender-based violence. So we are able to analyze the evidence that we collect, and we only form a conclusion where we have a number of different pieces of evidence indicating the same result, such that we say we have reasonable grounds to make that conclusion. So I accept the limitations, but I don't agree that the evidence that we collect is insufficient to form conclusions.
David, if I can build on that just a bit. So what a doctor can tell you, for example, is you're right that it provides a doctor or a medical professional can provide you direct evidence of what that medical professional has seen. But you're right, one, that the doctor can't, or the medical professional, whoever it is, can't present evidence of intent. And intent is required in order to, evidence of intent is required in order to establish that a war crime has been committed, one. And two, that evidence that the medical professional, whoever it is, presents to you, they can't present evidence of attribution. They can't actually tell you who it was, whether it was Hamas, whether it was IDF, that actually fired the round, say, using the sniper projectile as an example. They can't tell you who fired that. So these are massive, significant limitations that even if you piece together all the evidence you can collect, if you can't actually develop attribution of the projectile that the doctor is telling you, I operated on this child, I found only one projectile and it was embedded in the cranium. So the doctor is telling you what the doctor saw or the medical professional saw, but they're not providing evidence, one, of attribution, who actually fired that projectile, or two, what the intent and knowledge of the person who fired the projectile, whoever it was. And without that, we're not able to develop any actual conclusions on whether that specific attack complied with law of armed conflict.
But we use other evidence as well. The video evidence has been particularly important. We get video. We have, last I heard, over 17,000 pieces of digital evidence, photographs, videos, audio recordings. We often see the circumstances in which a doctor who has done this kind of examination on a body, the circumstances under which the child was actually hit. That is available on the video that we examine in many cases. So we are putting together the whole picture. We know the circumstances under which a child is hit. We have video with audio attached to it. We have the capacity to verify that. I should say, with artificial intelligence now becoming more popular, the verification task is becoming increasingly difficult. But we do have the capacity to date to verify a large proportion of the video evidence that we have received. And we often have eyewitness evidence as well from people who were there at the time and saw the child being shot. So we don't just rely on the doctor's evidence. That is one of the pieces of evidence, and an important piece of evidence that we can take into account. We don't, of course, speak to the individual soldier. We can only get to the point of intent by inferring intent. And here I see us being more like a police investigation or even a prosecutorial investigation. We're not the court. We're not deciding beyond reasonable doubt guilt or innocence, but we are acting like a police investigator or a prosecutor in gathering the evidence that is available and making initial conclusions. Now, what we would like to see in these cases is that individual soldiers going to trial, and let's test the evidence and let's examine them about the intent. I would certainly like to be able to interview the soldiers ourselves, which would enable us to be much more certain in the conclusions that we form. But as I indicated, we're prevented from doing that.
Well, I have been a prosecutor, military prosecutor. I have done these actually in practice, and I have advised on these incidents in combat. And so I know exactly what's required because I've done it. And the standard, now I'm going to read text from the Rome Statute, recognizing that Israel hasn't ratified the Rome Statute, but the war crimes that are reflected in Article 8 of the Rome Statute are consistent with the doctrinal understandings and the doctrinal application of Israel, as well as the United States, which also hasn't ratified the Rome Statute. So as a U.S. soldier, U.S. Army soldier who spent 22 years in the military, 7 years of which as a military lawyer, I still refer to the Rome Statute because it's especially for war crimes, because even for states that haven't ratified the Rome Statute, these are they're consistent with our doctrinal practices, even for the IDF, for Israel hasn't ratified the Rome Statute, or for the United States. And so the standards that we're using, this is I'm reading directly from the Rome Statute now as an example of a war crime. There are others, but this is just one example. Intentionally directing attacks against the civilian population, or intentionally directing attacks against civilian objects, that is, objects which are not military objectives. And so there is no substitute for understanding what the knowledge and intent is at the time. And the reason why the IDF, as you've said, very likely isn't prosecuting these incidents is if I can kind of channel a bit of my own practice, because I have engaged with IDF legal advisors in the MAG Corps, and so I understand their operational procedures are very similar to ours as well. They will not recommend war crimes prosecution if they don't have actual evidence that the person involved intentionally, that is knowingly and on purpose, intentionally directed attacks against the civilian population. There's no substitute for that. And so I understand that you kind of represent and you project that what you're doing is very similar to a forensic analysis or as a police or a prosecutor would do, but the standards that you're applying aren't the same standards that we apply, because we being military in practice, because our standard is we must have evidence that the perpetrator, whoever it is, the potential perpetrator, intentionally, that is knowingly, directed attacks against a civilian person or object. If we don't have that, there's no prosecution for war crimes. And I know that from practice because I've done it.
Yeah, of course. And I accept that 100%, Brian. The two things I would say in response is that, firstly, we're operating on a different standard. We're not operating on the basis of getting a conviction. I've drawn a comparison with police investigations and prosecutors because I find that comparison more useful than comparing us to a court. But we are different again. We are a commission of inquiry. But the second thing that worries me about your comment is that it implies that you need to have direct, almost confessional evidence of intent, something that the individual has said. But that seems to me a very, very high standard. That surely, well, let me ask you, in your role as prosecutor, have you prosecuted people on the basis of all the inferences that you draw from the entire picture, even if the individual denies an intent and has not said anything personally that would be by way of confession or admission of intent? How do you?
So that's a really great point, and I think the difference is the starting point. So as a prosecutor in practice, my starting point is I go to the person who was responsible for the attack, and I say, okay, what did you see? What did you say? Well, not me. I mean, the people who are involved in the investigation. As the legal advisor, I'm advising on this. So the investigator will go to the personnel who are responsible and say, okay, what were the factual circumstances? What did you see? What was your knowledge? What was your intent? We develop that evidence, and that's our starting point. Now, if based on what the person has said, if what we're seeing as from the actual circumstances of the attack, if it's just implausible, if the troop, whoever it is, the personnel responsible, if that person or they say, okay, this is what I saw, this was my intent, but then what we're seeing on the ground is so out of line with what that person's saying, then what we're looking at is evidence that the person may be fabricating what they saw, or what their narrative is. But for us in practice, the starting point is always what has that person said, because we need evidence of intent, and that means what their knowledge was. We have to understand what the circumstances were at the time, and understanding that there are different evidentiary standards. For a court, it's of course for many places beyond reasonable doubt, and it's different, reasonable certainty for a commission of inquiry. The standard doesn't change. The standard still is intentionally directing an attack against civilian persons or objects. And in practice, we start with what that person says. And for a commission, and this is just an inherent limitation, for a commission, you're starting with what have we seen on the battle space. And so the standard remains the same, but our starting points are completely different. Yeah. And that affects the military's ability it makes for a different impact on how the military is able to develop the understanding of what happened versus what a commission is doing after the fact.
Yeah, no, I agree with what you say. Of course, we would like to be able to examine, but we don't have an opportunity to examine those who are alleged to be the perpetrators. But can I give you one of the specific cases that we looked at, not in Gaza, but in the West Bank? A case of a 14-year-old boy who left his house, was shot. There was an Israeli patrol there at the time that he was shot, and was very seriously injured, but not immediately killed, and then lay on the ground surrounded by a group of 10 Israeli soldiers for 45 minutes while he bled to death. During the course of that period, his mother tried to get to him. He was shot outside his home. His mother tried to get to him, and 4 shots were fired towards her, hitting the windows and door of the home. There was an ambulance nearby that was prevented from reaching the child. And when the ambulance started to move forward, a driver and a paramedic in the ambulance both were targeted with the infrared, the light targeting on their forehead. Mm. Now, in that case, we had video of the whole period. We had eyewitnesses that we were able to talk to. We had other, more than one witness, I should say, and other people who were nearby or saw the consequences of what had happened. And in that case, we drew the conclusion on reasonable grounds that the child had been allowed to die. There was no fighting going on at the time that the child was on the ground for 45 minutes. That's why the soldiers were just standing around chatting and smoking. At one point, a soldier put a stone next to the child and took photographs, which to us indicated an intent to at least establish an argument that the child had been a stone thrower. Now, we drew the conclusion that the child had been deliberately allowed to die. We didn't say he was deliberately targeted in this case, but that the child had been allowed to die, a 14-year-old. Now, what conclusions would you draw from a case like that?
Yeah, I remember reading that, and there's a lot of compelling evidence from looking at the incident, not from the military perspective, but from an onlooker's perspective. It's difficult for me, and I tend not to speculate on what the intent of the personnel were at the time if I haven't heard from them, if I don't understand if I don't know what their understanding of the operational environment was at the time. As a former combat soldier and military lawyer, it's difficult for me to develop really overwhelmingly compelling conclusions about what was going on with those personnel if I don't have evidence from them. And so, I remember that incident really stands out, and I remember reading about that. But I also remember thinking, as I'm analyzing it as a former military practitioner, that there's a lot of compelling evidence from an observer perspective, but zero evidence, it seems to me, from an operational perspective. And I really, if I'm going to draw conclusions about what was going on from a military perspective, I really need to have evidence from that angle.
Yeah, can I just say something here? There's a lot of sort of legal argument here, but from a point of view of somebody who's um, just just considering it as a layman, who's not to say that this 14-year-old boy was actually a terrorist? And I want to extend that remark to say you've catalogued children as being the victims of what Israel has been doing, Chris. But how many of the so-called children who are under the ages of 18 have actually been hirelings of Hamas?
Well, I'm afraid, David, you have to go to law, and you've reversed the presumption in law. The presumption is that civilians are civilians until proven otherwise, and that children are children until proven otherwise. So you can't proceed on the basis that all 14-year-old boys are terrorists. You have to proceed on the basis that they are not, unless there is evidence to the contrary. And in this case, we have a kid who was leaving his home, just outside his home, was shot and eventually died. The Israeli military itself has not claimed that he had any weapons on him. The video evidence does not indicate any threat. There was no fighting going on at the time. So the kinds of indicators of a death in combat, certainly there was an Israeli patrol in the village at the time, but the indicators of a death in combat, a combatant in an operation that was active fire zone and so forth, were simply not there. And you can't act on the basis that this child is a terrorist unless you have some evidence for it.
But it wasn't my suggestion. I mean, this is one example you've given, Chris. My suggestion is a wider assertion that a very large number of the children that you consider to be victims of direct targeting by Israel are in fact terrorists and have been proven to be so.
Well, have been proven to be so where? Now, this again, it relates to what Brian has said, and which I agree with completely, about the need, the desirability of hearing from the military itself and so forth. In the case of the IDF, we hear assertions, but we never hear evidence. They never produce evidence. They have very occasionally announced inquiries, and we never get the results of the inquiries. They rarely result in any prosecutions. So there is no capacity even for the Israeli courts in open session to be able to test the evidence of the IDF when they present it to court. But so far as cases like this are concerned, no evidence is presented whatsoever. There are assertions made, but it was significant that the assertions did not include an assertion that this child was armed or even that he was a terrorist. That was not said at any stage by the IDF.
Brian, do you want to pitch in here?
No, same comment as before. Just I remember reading this about this incident from the report, and I remember, like, it stands out as one compelling incident in Judea and Samaria, but we still need evidence of knowledge and intent to understand, to develop if a war crime was committed, or potentially multiple war crimes were committed in this case, depending on the facts. I really, as a military practitioner, I really need evidence of intent and knowledge to fill in the gaps, if nothing else. We can observe what's going on from externally, and we can make reasonable guesses about what happened. But I really need to hear from personnel who are involved. And to Chris's point, it is, and it's been my practice or my experience as well, it is a rare occasion that the military presents to the public full details of an investigation that has occurred. One that really stands out to me was the U.S. Army, U.S. military in 2015, for the October 2015, the attack on the Médecins Sans Frontières Trauma Center in Kunduz, Afghanistan. That was one example. It was a very high-profile attack. Of course, I've studied it extensively in my work, and that was one example where the military went through great lengths to publish a significant portion of the investigation that was conducted internally, redacted, of course, but that was published to the public, and that's one example that stands out among dozens or hundreds of incidents of civilian casualties that I've been involved with, advising or studying from a military perspective for various reasons. There are compelling reasons that the military doesn't go through the trouble of presenting a lot of evidence to the public. One is that there's a lot of intelligence value in these investigations, even if they are redacted to potential adversaries. In this case, so for Israel, for Hamas, Hezbollah, Iran, etc. But also, unfortunately, it's the nature of war, nature of armed conflict, that there will be a lot of these incidents of civilian casualties. And if we made it a point to redact and then release to the public, the reports, the reports of investigation, every time this happened, or every time, or even in a lot of times, a significant number of incidents, that would end up being all that we do, rather than focusing on war fighting, which is what we're supposed to be doing. And so, as someone who's been in the military, and someone who is familiar with the IDF internal processes, these investigations are happening. The military is looking into to these incidents, and there are findings and conclusions and recommendations that are being presented to an internal audience. But there are compelling reasons why those are simply just not shared to the public, shared with the public. And that creates a significant limitation for all researchers, not only a UN Commission of Inquiry, but human rights NGOs, myself as a researcher, just independent scholar. That puts us at an evidentiary. It presents evidentiary limitations for us, but trying to fill in the blanks with what we can get, after the fact, or what we observe in the battle space, it's something, but it doesn't change the standard. And the standard for war crimes still is we need evidence that the personnel involved intentionally directed the attacks against civilian persons or objects.
I've read your material on Kunduz, Brian, and commend you on it.
Thank you.
And not only your analysis of it, I have to say, but also that was a rare incidence where the US military did a very thorough job in the investigation. But the work that you've done on it is top class.
Thank you very much, and it's continuing as well.
Well, that's good, because given that there is so much information that is available on Kunduz, including from the US military, it really is a rare example of a situation where there can be serious questioning of what's gone on and why it happened.
Absolutely.
So it's good and very important work. I understand the points that you make, but I come to a different conclusion. I understand the pragmatics of why the military does not provide its evidence, and I accept what you say, that if it provided its evidence on every case, it would spend all of its time providing evidence. But that says something in itself. But where I disagree is that if we take that approach, that we will only comment on a situation where we have had an opportunity to question those who were involved as to their intent, then we would take 99.9% of military incidents outside the scope of investigation and comment. It would basically mean that international humanitarian law is not worth the paper it's written on, because only 0.1% are ever subjected to external examination as to what actually happened. So I am absolutely committed to the fundamental principle that there should be no criminal trials in absentia. I think the whole concept of a criminal trial in absentia is an absurdity and does not meet the necessary standards of justice. But that's at the stage of a criminal trial. And one of the reasons why we see so few criminal trials for war crimes, crimes against humanity, is precisely because of the inability to have the alleged perpetrators brought before the court to be questioned and examined and their intent explored. But we still need to be able to investigate what happens, to look at allegations first, to receive them, then to investigate them. And then if the evidence is sufficient to form a conclusion, in our case, on the standard of reasonable grounds to conclude, well, I think that that's a proper and necessary function to make international humanitarian law, the law of war, effective. Otherwise, it's just words on pages that nobody ever knows whether it is being applied, complied with, or not. And that clearly is an unacceptable situation.
It may be unacceptable for an external observer, but for someone who comes from a military background, the purpose of law of armed conflict is to regulate the conduct of hostilities. And so, from my perspective, and I understand your perspective, and I encounter it routinely and very frequently with when I engage with friends and colleagues in the humanitarian space, just in general. I understand the impulse to want to analyze incidents and develop, to gather information, gather evidence, analyze incidents, develop findings and conclusions. So while I understand that impulse, from a military practitioner perspective, the way that I see it is, it's working. Even if we don't have the clarity on the outside on whether Israel or whether the United States or whoever is complying with the law of armed conflict, it's an internal function because it exists to regulate the conduct of hostilities. And so the reason why, and I can speak from the U.S. military perspective, because this narrative is very often presented for us as well, that there are very few prosecutions for war crimes because there's no kind of external check to make sure that the rules are being complied with. My experience is there are not very many prosecutions for war crimes because there are not very many war crimes being committed. And so we are assessing the evidence that we are able to develop. We are applying doctrinal standards, and we're not prosecuting because we've determined in the overwhelming majority of incidents that a war crime wasn't committed. And my understanding from external, from an outsider's perspective, kind of talking to MAG Corps members in the IDF, is that is their experience as well.
One of the comments made by outsiders is that the nature of military culture is a closed culture, and that unless there is independent external investigation, the military will always give a soldier the benefit of the doubt. Not necessarily saying that there was no crime committed, but that the benefit of the doubt goes in favour of the soldier in this circumstance. Do you see that in the work that you've done with the US military?
It hasn't been my experience because there's a very strong commitment to complying with law of armed conflict, applying it in practice, and enforcing it. And so I'll give you a textbook example of a war crime that was committed by a U.S. Army soldier. Staff Sergeant Robert Bales, this would have been in Kandahar, Afghanistan, snuck, I can't remember the year right now off the top of my head, but he snuck off of his forward operating base in Afghanistan with the intent to go find a village of civilians he attacked them and killed them, and then tried to burn the evidence and then snuck his way back onto the FOB, forward operating base. That's a textbook example of a war crime. If we look at, again, the United States hasn't ratified the Rome Statute, but if we pull it up as a template, because it is, again, consistent with our doctrine, if the standard is he intentionally directed attacks against the civilian population, that's exactly what he did. And there's no doubt about it. And so there is an inherent incentive within the military, again, speaking from my own experience, for what it's worth, to enforce the law of armed conflict. And so Staff Sergeant Robert Bales is not getting the benefit of the doubt. And, that we, again, in the U.S. Army, we have an incentive to investigate, and if the evidence is there, to prosecute. Because if we don't, if Staff Sergeant Robert Bales gets the benefit of the doubt, then we really are violating the law of armed conflict, and it really doesn't mean anything. And so I think I have a different perspective, and it's informed, and again, not to take away from external observers, because again, I'm no longer in the military. I am now a professor and an international law scholar, like many others who are in the civilian sector now. And so I understand the perspective, but I bring to the civilian sector my experience as a military prosecutor, as a combat soldier, as a military legal advisor, including in combat. And my perspective is that informed by that experience, and it has been my experience that we're not in the business. It's not common for us to just give a soldier or give a troop the benefit of the doubt. There's an inherent incentive to enforce law of armed conflict. We train our troops on it, and we expect them to comply with law of armed conflict. And if they don't, there's an incentive to investigate, and if the evidence is there, is to prosecute.
Can I ask you, Brian, a couple of questions regarding the report? The accessibility, to begin with, of the visual material that has been collected, which has not, I believe, got any real public scrutiny, and also the lack of identification of any of the people who are involved in these, which obviously would make it very difficult to investigate, with the identities of the people involved not being revealed.
Yeah, so this is an inherent limitation for someone who is not involved in the UN Commission of Inquiry, is we don't have access to the evidence that is collected and considered by the commission. And so, it's basically just, kind of, just as Chris has said, we have to trust on the outside that the military is doing what they say they're doing, and that creates an inherent limitation for us. Being on the outside of the commission, we have to just assume and accept that the commission has collected the evidence, and that they actually have the evidence, and that they've considered it, and they have certainly reached a conclusion, but it's unclear for us, because we don't have access to that evidence, whether we would reach a different conclusion based on looking at the same evidence.
No, I think that's a fair comment. We make all of our evidence, and including identifying information, available to courts that are relevant where requested, courts that are operating according to international standards of justice. We don't send it off to any kangaroo court. And so it is made available. Our practice, I should say too, this goes back to the presumption of innocence, really. We don't name any of the individual soldiers in any of our reports, even if we have names. Our view is that it would be not appropriate to do so, given the nature of our investigations. We are prepared and do name those in senior positions of command responsibility who hold public office. And we consider them in a different situation. It is command responsibility rather than direct perpetration. But also they are public office holders occupying offices that are clearly within the chain of command. But our practice, and the practice, so far as I'm aware, of all UN Commission of Inquiries is not to name individual perpetrators, even when we have strong evidence of that. And that just reflects the fundamental principle of the presumption of innocence. And this information is made available to courts confidentially, but is not publicly disclosed beyond that.
But when it comes to the identity of the victims here, Chris, you have not revealed them because you say that the IDF is so vindictive that if that was to be the case, they would carry out retribution. They would carry out retribution against these so-called victims.
Could rather than would, David. There is a real risk. There is a war going on, and there's been a war going on for 100 years. And in those circumstances, it would be as irresponsible for us to name the victims and the witnesses who have given us evidence as it would be to name the soldiers against whom we've collected the evidence. It is a continuing active conflict. If there were no possibility, so this is the could rather than the would, if there were no possibility of harm to witnesses, we would be willing to name them. But in a conflict situation like this, we cannot be sure that there is no possibility of harm.
And in the case of people turning up in hospitals with bullets in their head and vital organs, like you say, how can you definitely substantiate that Israeli soldiers have been causing this and it hasn't been done by Hamas, who are carrying out vindictive acts against people that have shown opposition to them?
Well, one thing is the nature of the wound, is one aspect of it. We have military experts who are often, not always, but often able to identify the nature of the weapon that caused an injury. And sometimes that weapon is simply not in the hands of Hamas, it's in the hands of the military. But more than that is the fact that we have corroboration. You know, we have the videos of the incidents in many of these cases, where we're actually able to see what's going on at the time and where the fire is coming from and so forth. You know, the case of the two brothers, 9 and 10 years old, who were shot and killed by a quadcopter after the ceasefire in November last year. There was no fighting going on at the time. There were Israeli soldiers present, but we have the video evidence that indicates they were killed by a quadcopter. Hamas does not have quadcopters. So in that case, it's pretty simple to say that the firing that resulted in the killing of these two brothers, 9 and 10, came from the Israeli forces.
But what about the fact that these could have been in close proximity to other individuals who were actually adult Hamas operatives, and this is just the collateral damage that occurs in war?
In that case, first, there was an eyewitness, the boy's father. Second, there was the video evidence that indicated that there was no fighting taking place at the time. And third, the IDF hasn't claimed that. We're not going to assume that that's the case if the IDF itself is not making that claim. The IDF says that these two boys, 9 and 10, were shot because they were suspicious. A 9 and 10-year-old boy in a situation where that's taking place.
The age of the person who was shot, 9 and 10, doesn't change the standard, right? So the standard is
the standard, David, but it changes the level of responsibility. My understanding, you're the expert in the military, not me. My understanding that these quadcopters have very good infrared ID that can, and sometimes even video ID that can enable the identification of the size of the individual, how they're interacting, follows their circumstances pretty closely. So the level of responsibility is greater when it's children under international law. And in this case, the quadcopter, which is sending back all this imagery before being instructed to shoot, would have been able to identify two individuals who were of the size of 9 and 10-year-olds, or, that is pre-adolescents.
Sure. I mean, it's difficult to tell specific ages or even an age range potentially from visual evidence that we get from an ISR, intelligence, surveillance, and reconnaissance platform. So a quadcopter in this case. But the standard is, were these two individuals who ended up being shot, were they assessed at the time to be civilians taking a direct part in hostilities? And if they were, that would be what the IDF refers to as being suspicious. Well, what was it about their conduct that made them suspicious? Were they assessed to be civilians taking direct part in hostilities, regardless of their age? And on what basis was that determination made? And if they were determined to be civilians taking direct part in hostilities, then was the attack directed against them? And so, again, this is a huge evidentiary gap that exists from the outside. And as an external observer, we can look after the fact and say, well, these were 9 and 10-year-old boys who were killed, apparently doing nothing, but we don't know what was perceived at the time, and and on that basis, the attack was authorized and carried out. We just don't have access to that information. If we don't, again, we don't know if they were assessed to be civilians taking direct part in hostilities, and whether the attack was therefore directed against them on that basis.
Yeah. And so to me, this is a very strong example of the situation that I mentioned earlier, where, we can always give the military the benefit of the doubt. We can say we don't know, or we can conduct an investigation as we did and get as much evidence as we can. And if we are satisfied with the level of evidence that we've got, can form a conclusion based on reasonable grounds. Now, that is not a criminal conclusion, but I think unless we do that, there will never be any questioning of the killing of children.
And as a military practitioner, I look at this and say, I don't assess that we have evidence that, even on reasonable grounds, that that the personnel involved intentionally directed the attack against a civilian, because we don't know.
Yeah. Okay. Well, I accept we're coming at it from different perspectives, and I respect the position that you state.
But the very nature of the report, though, is without it being strongly substantiated, it seems to opportunistically utilize incidents concerning children that exploit grief, exploit knowledges of grief and the innocence of children, that grossly oversimplifies what is a complex situation where you've got all these political realities going on the battlefield. And aren't you really trying to tug at the heartstrings of people and gain support for your views and sympathy for the victims of war that have really been started by Hamas by utilizing children? Isn't this really a cynical opportunism by you, Chris, in your report?
No.
What do you see as the basis of the report, Brian? Do you see it as really exploitation here of the images of children? I mean, I've seen it with organisations that, like Amnesty, that actually utilise a lot of this victimhood in gathering donations for their cause.
I understand that reception for the report, but as a researcher, I focus on evidence, law, and methodology. And I think we can have a reasonable discussion about whether the evidentiary standard has been met. Certainly the commission the personnel who were, the commissioners would not put in their report, an accusation unless they felt that they had sufficient evidence for it, for that accusation. And so the question becomes, we understand what their evidentiary standard is, reasonable certainty. We can have a discussion about whether the evidence actually does reach reasonable certainty or not. We can have a discussion about whether the law that aspects of international law that the report accuses Israel of violating, whether those articulations are consistent with the doctrinal standards that we apply in practice, and then the method that's developed, in that report to apply the evidence and apply the law to reach findings and conclusions and recommendations. And that's what I tend to focus on, rather than, again, I understand the perception that a sense of victimhood is developed for emotional purposes. I understand that approach and that reception, but my focus as a researcher is typically on what the evidence is, what the articulations of the law are, and then the methodology for that report.
And that's what I'm able to discuss as we have today. It's been really important for David to say, Brian to say your views, to present them, for me to respond and express my views. But David, it's absolutely impossible to respond to ideological prejudgments. I've got nothing that I can say. But having a discussion, as Brian has indicated, on methodology and evidence and law and so forth, is something that we can do and should do.
Yeah, we haven't
one of
mentioned
the major. Go ahead, David.
Yeah, we haven't mentioned the charge that Hamas uses civilians as human shields, and this would be a large causative factor, wouldn't it, in the casualties of children in this conflict, wouldn't it, Chris?
Potentially so, but again, this is a very big subject to enter into at the end of the conversation.
Yes,
but let me just very briefly, again, we have found and we have reported some instances where that has occurred. We have also reported incidents where the Israeli forces have used civilians as shields, including children. So it cuts both ways. But one of the issues that we have struggled with throughout, with the IDF's comments about the use of hostages, is getting evidence from the IDF to that effect. Where we've had evidence, and there are occasions where we've had evidence, we have reported it. But the IDF, again, asserts it, but does not provide the evidence.
So, Brian, do you want to sum up and perhaps explain why the IDF is rather reluctant to provide the kind of evidence that the Commission has sought?
Yeah, I'll touch briefly on the issue of human shields, and then before we wrap up, we haven't really mentioned much at all about the allegation of genocide, and I think that's the banner allegation from this latest report, conference room paper, builds on from the previous one. So on the issue of human shields, I think this is an issue of terminology, and so Hamas routinely and deliberately hides and fights among the civilian population. Whether or not that's regarded as human shields, using a human shield again involves intent, and so that would be taking a civilian who's not taking direct part in hostilities, deliberately putting them within my military objective in order to shield me from attack, from my adversary responding to me. That's the use of human shields. And so whether or not the IDF has presented evidence of Hamas doing that, there's overwhelming evidence that Hamas deliberately hides and fights among the civilian population, that they'll put rockets and mortars, etc., in their firing positions from within, refugee camps, within tents, understanding that the IDF, if they attack, that they will be attacking within a civilian area. And so that is a violation of the requirement to take passive precautions or to take feasible precautions against the effects of attack. So whether or not we refer to that as human shields, there's overwhelming evidence that Hamas deliberately hides and fights among the civilian population. That is a violation of the requirement for passive precautions, and that impacts, of course, the perceived civilian casualties as the IDF ends up fighting against an adversary that hides and fights among the civilian population, whether or not they use human shields. On the issue of genocide, again, understand that the conversation is kind of nearing the end. Unfortunately, I wish, I've enjoyed this conversation immensely, and I would welcome the opportunity to continue it, of course. But we haven't really gotten to the allegation that really kind of draws what I think probably is the most attention, and that is the allegation that Israel is responsible for genocide. I have noticed that it's worth pointing out that this is one of the occasions that the conference room papers actually present the doctrinal definition for what genocide is. And so it correctly refers to the Genocide Convention, again, reading from Article 2, that it's any of the 5 enumerated acts that are committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. And so the report, I think, does a fantastic job of articulating what the actual doctrinal standard is. And so the law is correct. There's no issues with that. But my issue from a methodological perspective is how the evidence is presented. And so the conference room paper, this is the one from September 2025. So the latest one from June 2026 refers back to this one. This conference room paper takes excerpts of statements of Israeli officials, much like Human Rights Watch and Amnesty International and others have done. So they take examples. For example, on October 9, 2023, 𝔼𝕝𝕤 Gallant says that the IDF is fighting human animals. And 3 November 2023, that Prime Minister Netanyahu has said, remember what 𝔸𝕟𝕥 did. And so it takes these expressions of intent, very often taken out of context, right? So Gallant was referring to Hamas fighting against human animals rather than the Palestinian population. And so what the intent methodology does is it takes excerpts of statements from elected officials, often taken out of context, rather than looking at what the actual stated intent of the military operation is. And so I've got just a couple of examples. So this is in October 2023, a statement by Prime Minister Netanyahu said that the goals of our military operation, which was entering then at the time the second stage, the goals are clear: destroying Hamas's military and governing capabilities and bringing the captives or the hostages back home. And so this was very early in the conflict. Again, October 2023, October 28th. And then 2 years later, Netanyahu once again said that the aim, this is on the 2-year anniversary of October 7th, the terrorist attacks. Netanyahu said, the aims of the war are to return all the hostages, because at the time they hadn't been returned yet, and to destroy the Hamas regime and ensure that Gaza no longer poses a threat to Israel. So these statements from elected officials of what the actual military campaign, the strategic objectives of the military campaign are never incorporated into the evidence of intent. Rather, it's just a couple of incidents of elected officials saying things like, remember what 𝔸𝕟𝕥 did to you, and we are fighting human animals, that are, again, taken out of context, rather than actually looking at what the stated objectives of the campaign, the military campaign, are. And so if the intent is to destroy Hamas in whole or in part as such, in order to stop the enduring threat that's posed to Israel by Hamas, then that is not genocide. And so we really need evidence that the intent is to destroy the Palestinian people in whole or in part. And one of the major shortcomings that I see in the Commission of Inquiry method is it takes these selected bits of political messaging out of context rather than actually looking at what the stated objective of the military campaign actually is and assessing it from there.
Given the time, just one comment first about the first part about the human shields and Hamas being embedded. We have referred to that on many occasions. We've actually, I mean, this may be, David, a surprise to your listeners. We have actually found on many occasions that Hamas is responsible for the commission of war crimes. We have said that consistently over the last 3 years. And one example of the commission of war crimes is the firing of rockets from Gaza into Israel, targeting the population centres, the treatment of the Israeli hostages while they were in Gaza, the events of 7 October 2023, and also more recently, the other report that we haven't even discussed that we released in June this year, at the same time or a week before, the one dealing with children, looked at Hamas killing of Palestinians in Gaza and some of the executions and other activities. And we found that they were war crimes and crimes against humanity. So we also do deal with these issues. And I agree that the issue of fighting within a civilian population is a very serious one. And that is one where we do have evidence and we have spoken. On the subject of genocide, you know, at this stage, after we've been going for more than an hour, I can't even begin to get into it. I will say one thing, however, relating to the quotes that we've used, the quotes that you've used, Brian. Many statements have been made about what the objectives of the Israeli military occupation has been, and we did not rely on the quotes as the only evidence. Rather, we sought to look at the military strategy that the Israeli Defense Forces used under the instructions of the civilian leadership to see what were the real motivations. And the quotes have to be taken in conjunction with the strategies that have been employed and the actions that have occurred. But, David, get us both back to discuss genocide. Let's do it properly rather than having a very short exchange at this stage of the conversation. Let's just have a session, Brian and me, focused exclusively on genocide.
Well, that's I'm glad to take that up, but just one thing I wanted to say about what you mentioned. You did say that Hamas targeting of Palestinians in Gaza was included in your report. According to the Israeli government assessment of your report, you devoted 4 paragraphs to that topic in 100 pages of that report.
No. The other report in June last year, half of the report was devoted to that subject. Half of it dealt with Israeli settlers in the West Bank, and the other half dealt with the Hamas killing of Palestinians in Gaza.
Okay, well, that's something we can look into as well. Now, I can announce, I think, Brian, is that okay with you, that you are planning to come to Australia in mid-October?
I am, yes, and that's safe to know. The details are still being worked out at this point. But I am looking at, I haven't booked air travel or anything like that, but I am looking at early October, and I would like to do a series of public engagements that involve this conversation and then the broader context as well while I'm there. So fingers crossed that it does work out.
So hopefully you're...
When you come, Brian.
Sir, say again, sir?
It'd be nice to catch up with you when you come.
Indeed, I would like that. Thank you.
Yeah.
Well, that's what I had in mind, and hopefully you'll be around at the time, so we don't have to do this virtually, Chris. We can do this actually face to face.
Yeah, be good
in some environment, conducive environment. Well, thank you both for devoting so much time to this discussion today, and we've obviously opened a can of worms, and looks like we're going to continue.
All right. Well, thank you very much for hosting, David and Chris. I've really enjoyed getting to know you and meeting you here, and I've really enjoyed our discussion, and I hope we can carry it forward.
Yeah, me too. I don't think we've opened a can of worms, David. I think we've started a very useful dialogue.
It's called a euphemism, isn't it, Chris?
Maybe. Thank you.
Thank you both.
Okay. Bye, David. Bye, Brian.
Bye-bye.